Why does it take so long to bring a civil lawsuit involving medical malpractice in the state of New York? Would you like to know the answer? Come join me as I walk near the water as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Every one of my clients asks the same exact thing. How long is my case going to take? Why is it taking so long? What's the delay? I don't understand. So let me peel back the curtains and show you and explain to you what the delay involves. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. All right, so here's what happens. When you come to us and now you say, listen, I think I may have a valid medical malpractice case, the first thing that has to happen is we have to meet with you for quite an extended period of time. Then, after learning the details of your particular matter, now we have to start the process of obtaining all of your medical records. Now, it would be great if we had all of your records at the touch of a button and instantly we had all of your records going back 10 years, 15 years, 20 years. But unfortunately, that doesn't happen. So what does happen is you have to give us permission to go ahead and get copies of your medical records. And from each and every doctor you have seen over the period of time that we're looking at, as well as for years prior. Now, those records may involve radiology imaging, such as CAT scans, MRIs, or X-rays. That request for records will involve doctor's office visits. It will also involve hospital visits. And many of these hospital visits are hundreds, if not thousands and thousands of pages, depending upon how long you were in the hospital. So all of that is done individually for each individual doctor and each individual hospital and each radiology facility. And in order to do that, now we have to send off a letter together with your permission slip to get copies of those records. Those different medical facilities then, when they get around to it, notify us and say, okay, in order to get a copy of Mrs. Jones's records, you have to pay us X number of dollars before we release them. Now we get that letter, we then have to write a check, and now we have to wait a period of time for them to go ahead and process that check, make copies, and send us those records. This takes months in order to obtain your records. And many instances, it becomes very difficult where we have to chase down staff at the various doctors or hospitals because they haven't gotten to us in a timely fashion and they haven't gotten back to us to at least tell us, okay, how many pages are involved in the record, how much does it cost, let's go ahead and get copies. Now, having said that, it could be many, many months to obtain all of your records. And although I will review those records as they come in, I can't send out your records to have them evaluated by a medical expert until I have obtained all of the necessary records in order to evaluate your case. This is before any lawsuit has ever started. So this is the initial investigation stage. And now it takes many, many months. It could take 6 months. It could take 9 months. It could even take longer. And in that instance now, we are still waiting for all the necessary records to come in. So what else happens? Well, at this very initial stage, once we do obtain all the records that we feel are necessary to determine whether or not you have a valid case, then we have to reach out to one of our experts to then send out those records, and now the expert has to review all of those records, and that can take many more months. So by the time we hear back from our expert, now a considerable amount of time has gone by since your incident has occurred. Now, after sending out the records to a medical expert, it will often be months before we hear back because now the medical expert has to go through thousands of pages of your record in order to analyze and evaluate whether you have a good basis for a case. Assuming that the expert now confirms that in fact you do have a good case, now is the time that we have to prepare the documents called a summons and a complaint, which actually get your case moving and get your case started in the judicial system, in the court system in New York. Once we go ahead and file this document called a summons and a complaint, now we have to take that document and actually deliver it to the various people and entities and corporations that you have sued. They have a certain amount of time in which to answer the allegations in your lawsuit. And they will do that by having an attorney represent each of the different doctors and each of the different hospitals respond by serving what's called an answer. And they have a limited time in which to do that. Once the defense goes ahead and serves an answer, now it is our obligation as the attorney who represents you, the injured patient, to notify the defense and say, hey guys, here is exactly what we believe each of the doctors involved did wrong. And here are the injuries that our client experienced and suffered because of the wrongdoing by each of these doctors and hospital staff. That's known as a bill of particulars. Along with that, we have to serve what's known as discovery demands. This is a very lengthy list of things that we believe we need in order to understand in more depth what occurred here. Because just getting your medical records is not enough. We need much more information from the defense in order to learn the details and the extent of what happened here. Now, after we send off this packet of documents, which takes quite a while to prepare, the defense has a period of time in which to respond to those demands for discovery. We will then notify the court, and the court will then, at some point, months down the road, tell us, okay, ladies and gentlemen, now we are going to set up a schedule for when things are going to take place in your particular case. That's known as a preliminary conference. So this is all what goes on behind the scenes way after your incident has occurred. Now, we have to determine when depositions will take place. And in case you're not aware, a deposition is a pretrial question and answer session that takes place in your attorney's office. Each of the parties involved will be questioned by the attorneys who represent the other side. So, the first people to be deposed, the first people to be questioned will be you, the injured patient. And if you have a spouse, your spouse will likely be questioned as well. From the time of the preliminary conference, it will be months before your deposition will go forward. And you might be saying, why? I don't understand. We have all the documentation, we have all the records, we know what went on. Yes, that is true, but the defense doesn't. The defense doesn't know all the details yet. The defense does not have copies of your medical records yet. They need to do the same type of initial investigation that we did when you first came to us. And how does that happen? We are required to give them permission slips that you have signed that authorizes them, the defense, to go ahead and get copies of your medical records directly from the various doctors and hospitals where you have been treated. And just as it took us many months to go ahead and obtain those records, the same exact thing happens with the defense. So they're doing the same initial investigation, but now many months later, and now we have to give them the opportunity to go ahead and get those records. After a period of months, we now assume that they have obtained most, if not all, of those records. If by some chance they have not, then they would like copies of the records that we have, they will ask us for copies and we will produce them and provide them so that now they have a better understanding of exactly what occurred. If we tried to set up your pretrial question and answer session known as a deposition, lawyers also call it an examination before trial, they would turn around and say, wait a second, we don't have the necessary records to fully understand your client's history, to fully understand what happened to her before this incident and also after this incident. In that instance, they are absolutely right, and we would have to push back your deposition date because they did not have the necessary documents to be fully knowledgeable before going ahead and asking you lots of questions during your deposition day. Once your deposition day comes and goes, and now let's say you are married and your spouse is also questioned, now is the time that we have to go ahead and schedule the doctor's depositions and any hospital staff that we need. And I will tell you that this takes months and months to accomplish because we need again to make sure that all the parties are available, including the doctor who is going to be questioned. And that is often challenging. Why? Because not everyone is on the same timetable or schedule, even though we would all like to be. So that encounters further delay. And once we do finish the first doctor who needs to be questioned, now I have to go ahead and schedule the second doctor and the third. And there's a gap in time between each of these depositions. Because you have not heard from your attorney, you think that your case is moving at a snail's pace. And in some instances, you might be right. But not for the reasons that you think. Not because your attorney is lazy, not because your attorney isn't doing anything on your case, but because it takes time to schedule these depositions. It takes time to gather the medical records. It takes time to go ahead and get these demands for discovery responded to, and responded to properly and fully. Don't think for a second that just because a considerable amount of time has gone by from the time of your incident or even the time that your lawsuit was started, that nothing is really happening on your case. I promise you, there's quite a bit going on in your case, but it goes on often behind the scenes, and we tend not to involve you in those minute details. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.